On behalf of Brinks, Gilson, and Leone, hello and welcome to today's virtual panel discussion entitled Patent Prosecution Strategies in the Wake of USPTO's Myriad-Mayo Guidance. I am pleased to be joined by today's presenters Bill Boudreau, Rashad Morgan, and Jennifer Fox. Bill Boudreau is a shareholder out of the firm's Ann Arbor office and co-chair of the Biopharma Group. Bill has been a patent attorney specializing in pharmaceuticals and biotechnology since 1992. His experience includes close to 15 years as in-house counsel in the pharmaceutical industry, including roles as patent counsel at Pfizer, Inc. and Eli Lilly and Company. Bill represents a broad range of biotech and pharma clients, ranging from large companies to startups. Rashad L. Morgan is in the firm's Research Triangle Park office and focuses his practice on all areas of intellectual property law, including patent prosecution both in the U.S. and abroad, patent litigation, due diligence review, and opinion work. Rashad has experience representing clients in a variety of industries, including chemistry, biotechnology, medical devices, and mechanical arts. Jennifer Fox is counsel in the firm's Research Triangle Park office and has over 18 years of experience in the pharmaceutical and biotechnology industries as a research scientist and patent attorney. Prior to entering private practice, Jennifer was an in-house attorney with GlaxoSmithKline, Novozymes North America, Inc. In addition to her law degree, she holds a Master of Science in Molecular Biology and Biochemistry and worked as a research scientist at NIH and Glaxo Wellcome, Inc. She was named an Emerging Legal Leader by Lawyers Weekly in 2010 and most recently received the honor of being selected as a North Carolina super lawyer in intellectual property. This virtual panel offers 1 hour of CLE credit in Illinois. We're happy to apply for CLE in other states at your request. Please note the window below the video that states CLE tracking. There will be random check-in points during the discussion where you will be asked to enter basic information into the window provided to prove your attendance. After today's program, your certificate of attendance will be sent within 10 business days. Please feel free to ask any questions to the panelists during the presentation in the chat window to the right of the screen. Their emails will be given at the end of the program as well. Our panelists' biographies and today's presentation can be found in the links at the top of the screen. Click there to download them at any time during the program. And now, today's presentation, Patent Prosecution Strategies in the Wake of USPTO's Myriad-Mayo Guidance.
Good afternoon. I'm going to start the webinar off with a brief overview of the Supreme Court's Myriad and Prometheus decisions, which involve subject matter eligibility for patent claims involving laws of nature and nucleotide sequences. After that, I'll provide a brief overview of the PTO's guidance, which was developed in response to these decisions, although you'll see that the guidance appears to extend well beyond the issues contemplated by the Supreme Court in those cases. Rashad will follow with how the court decisions may affect, how recent court decisions may affect current guidelines, and also Jennifer Fox at the end will follow with prosecution strategies for your consideration. 35 U.S.C. 101 provides the baseline for patent subject matter eligibility. Under the statute, patent may be granted for any new and useful process, machine, manufacture, or composition of matter. The Supreme Court has carved out several exceptions to this rule. In particular, you're not allowed to patent laws of nature, natural phenomena, or abstract ideas. Today's discussion deals with two of these exceptions, laws of nature, which the Supreme Court discussed in Prometheus, and natural phenomena, which the court discussed in Myriad. In Prometheus, the Supreme Court considered the patentability of a claim reciting a method of optimizing therapeutic efficacy for treatment of a gastrointestinal disorder. The claim recited two steps. The first step involved administering a drug which would provide 6-thioguanine to a patient. The second step involved determining the level of 6-thioguanine in that patient. Finally, the claim included a where-in clause which described the level of 6-thioguanine in the patient that would indicate a need to decrease dosage to avoid potential toxicity issues, and a level that would indicate a need to increase dosage to increase efficacy. According to the court, a method claim that recites a law of nature is not patentable when it simply adds the words "apply it to the law of nature," The claim lacks an inventive concept that would distinguish the invention from the natural law itself. The claim simply limits the law to a particular technological environment, or it simply instructs the user to engage in well-understood routine or conventional activity. Applying these principles to the claim at issue, the court found the claimed method unpatentable. According to the court, the toxicity and efficacy limits for 6-thioguanine were laws of nature. The court considered the administering step and determined that it simply limited the law to a particular technological environment, that is, doctors who treat patients with certain diseases with thiopurine drugs. Next, the court considered the where-in clause and determined that it simply tells the doctor about the natural law and at most suggests that the doctor take the law into account when treating a patient. In effect, the where-in clause adds the words "consider applying it" to the law of nature. Finally, the court considered the determining step and noted that methods for determining metabolite levels were conventional and well known in the art. Accordingly, the court held that the recited steps were not sufficient to transfer unpatentable natural correlations into patentable subject matter. Moving on to the Myriad case, the Supreme Court next considered the patentability of DNA products, which are contemplated by the natural phenomena exception to subject matter eligibility. Myriad involved claims directed to two types of DNA products. The first is referred to as isolated DNA and is essentially obtained by carving a discrete nucleotide segment out of a naturally occurring DNA molecule. The isolation process may result in some changes to the bonding structures from the original DNA molecule. However, the segment retains the natural nucleotide sequence, which stores the genetic information of interest. The second type of DNA product is referred to as complementary DNA, or cDNA. cDNA is essentially a lab-made copy of a natural DNA sequence, but because of the copying technique, the amino acid substituents and sequencing may differ between cDNA and the copied DNA. The differences, however, are dictated by the laboratory technique, which relies on natural physical principles and phenomena. One thing to note, neither type of DNA at issue in Myriad is found in nature. Both types are created in the laboratory. The Supreme Court found that isolated DNA is not patentable. According to the court, a naturally occurring DNA segment is not patentable merely because it is isolated. Now, this suggests that naturally occurring DNA segments are not per se unpatentable. The court also noted that the location and order of the nucleotides in the isolated DNA existed in nature before Myriad found them. Therefore, the relevant genetic information in the isolated DNA segment was the same as in the natural DNA segment. In addition, the court noted that merely separating a gene from its surrounding genetic material is not by itself an act of invention. Remember, however, that the isolated DNA segment is not structurally identical to the natural DNA segment. The court rejected this argument under the circumstances presented in the case because the claims at issue did not describe the chemical composition or rely in any way on the chemical changes resulting from isolation. Again, this suggests that the court is not establishing a per se rule concerning naturally occurring DNA segments, and that such segments may be patentable, for example, where the isolated compound as claimed has structural or functional distinctions over the natural compound. The court reached a different conclusion regarding cDNA. There, the court found that the cDNA at issue was patentable. The court noted that cDNA was non-naturally occurring and was created in a laboratory. According to the court, the lab technician unquestionably creates something new when cDNA is made. While the cDNA claim at issue was found patentable, the court noted that there may be cases where a cDNA is not patentable. For example, where the cDNA segment is indistinguishable from the natural DNA segment. This slide's for those who are keeping score. Isolated DNA and cDNA are each created in a laboratory. Neither is found in nature. Both have nucleotide sequences that are dictated by nature, and both are formed by routine processes. So why the difference in outcome? The difference appears to depend on both structural and functional considerations. The DNA compounds at issue are useful for the genetic information functionality resulting from the particular nucleotide sequences. The cDNA at issue in Myriad had a distinct nucleotide sequence and therefore different functionality from that found in nature. On the other hand, while isolated DNA can be structurally distinct from the natural compound, the claimed isolated compound had the nucleotide sequence and presumably the same genetic functionality as the natural DNA. So you can imagine Myriad and Prometheus decisions have had and will continue to have a profound effect on the patent law. Some estimate that the Myriad decision alone could invalidate over 8,000 composition of matter patents covering isolated DNA. The Prometheus decision casts a cloud over the validity of medical treatment patents claiming drug screening methods, diagnostic methods, treatment methods, among others. Going forward, there will also be challenges in the patent office as examiners and patentees struggle to figure out how to apply these decisions. Which leads us to the second part of the discussion and the USPTO's guidance for determining subject matter eligibility of claims reciting or involving laws of nature, natural phenomena, and natural products, which I will refer to as the USPTO guidance or simply guidance. The USPTO guidance issued on March 4th, 2014, and includes new examination procedures that purport to address the Myriad and Prometheus decisions. The PTO is eliciting feedback on the guidance and hosted a forum back on May 9th, 2014. We'll start out with what the guidance does not cover. It does not apply to abstract ideas. Claims reciting abstract ideas will continue to be examined under MPEP Section 2106 and the 2010 Bilski guidance. The guidance does, however, have broad applicability beyond abstract ideas to any claim reciting or involving laws of nature, natural principles, natural phenomena, and so-called natural products. So what is a natural product? Recall that Myriad involved a particular type of natural compound, DNA segments. The guidance goes much further and embraces claims reciting or involving, among other things, chemicals derived from natural sources, proteins and peptides, and other substances found in or derived from nature. The guidance establishes a three-step inquiry for subject matter eligibility. First, is the claim directed to a statutory category, a process, machine, manufacturer, or composition of matter? If no, then the claim is not directed to patentable subject matter. If yes, then we proceed to the second inquiry, which is, does the claim recite or involve one of the four USPTO exceptions, law of nature, natural principle, natural phenomena, or natural product? If no, then the claim is directed to patentable subject matter. If yes, then we proceed to the final inquiry, which is, does the claim as a whole recite something significantly different than the exception? In order to determine whether claimed subject matter is significantly different, the examiners are provided a number of factors which they're asked to weigh. In total, the guidance lists 12 factors, 6 that weigh towards subject matter eligibility, 6 that weigh against. And in practice, these factors collapse down to only a handful of inquiries. For example, there are only 2 factors that apply to product claims. According to the guidance, a product claims subject matter that is significantly different from a judicial exception where the claimed product is markedly different in structure from naturally occurring products. On the other hand, claimed subject matter is not significantly different when it is not markedly different in structure from naturally occurring products. Therefore, whether or not a product is significantly different depends on whether its structure is markedly different. The guidance does not propose a test for determining whether a structure is markedly different. With respect to method claims, the guidance sets forth a number of factors to consider, including whether the claims include steps that impose meaningful limits on the claim scope, whether the claims include steps that relate to the judicial exception in a significant way as opposed to steps that constitute insignificant extra solution activity, whether the claims do more than instruct a user to apply the judicial exception, whether the claims recite a machine or transformation that implements the judicial exception, whether the claims include steps that constitute more than well understood purely conventional or routine activities, whether the claims add nothing more than a field of use. My last slide lists a number of observations concerning the breadth of the guidance in comparison with the recent Supreme Court decisions that the guidance purports to address. As I mentioned earlier, Myriad involved a very specific type of natural compound, DNA nucleotide sequences. The guidance, on the other hand, requires examiners to scrutinize claims involving all substances, either found in or derived from nature, which extends well beyond the scope of Myriad. The guidance also appears to foreclose patentability of isolated DNA compounds, which is unsupported by the Myriad decision. According to the guidance, merely isolating a nucleic acid changes its structure, but that change does not create a marked difference in structure. The Supreme Court did not hold that isolated compounds were per se unpatentable, or that the isolation process necessarily could not lead to patentable compounds. As I mentioned earlier, the Supreme Court's decision noted that the claims at issue in the case did not rely on the chemical changes resulting from isolation. The court did not rule on the issue of whether a claim's structural change resulting from isolation could confer patentability. In addition, the guidance raises scrutiny on other types of claims not contemplated by Myriad or Prometheus, such as claims directed to novel product combinations, methods of use or treatment, and even methods of manufacture. These types of claims are likely to be subject to extra scrutiny if they involve natural substances or derivatives. So with that, I'll turn it over to Rashad.
Thank you, Bill. Once again, my name is Rashad Morgan, and I'm an associate attorney in the Research Triangle Park office of Brinks, Gilson, and Leon. Today, I will speak about the general sentiment of the public to these guidelines issued by the Patent Office, the Patent Office's position regarding these guidelines, and some cases coming up the pipeline that may have an effect on the application of these guidelines going forward. In view of comments received by the Patent Office regarding the guidance, a public forum was held on May 9, 2014 to receive public feedback from organizations and individuals. The forum provided an opportunity for members of the public to present their thoughts regarding the guidance and whether the guidance properly interpreted the Supreme Court precedent regarding the subject matter eligibility under Section 101 of the Patent Act. In addition, it gave the Patent Office the opportunity to explain their rationale behind the issuance of the guidance. During their presentation, the Patent Office generally presented their position as follows. The guidance is not solely limited to Myriad. Rather, the guidance addresses Myriad in the context of other Supreme Court cases, including Chakrabarty, Mayo, Funk Brothers, and Flood, and thus applies beyond the isolated DNA at issue in Myriad. In support of this decision, the Patent Office stated that Myriad explicitly relies on prior Supreme Court cases, such as Chakrabarty and Mayo. The Patent Office also stated that the Supreme Court made it clear that naturally occurring things is a broad term. Lastly, the Patent Office cited several cases in support of the position that mere discovery of nature's handiwork is not patent eligible. The Patent Office emphasized that there are no bright line rules or per se eligible categories. Rather, the guidelines give a flexible test that accommodates all technologies and allows examiners to consider relevant factors, related evidence, and the claims as a whole before making a conclusion. The Patent Office also further explained the significantly different standard, which requires a claim as a whole must recite something significantly different than the naturally occurring thing by itself. The Patent Office asserts that the Supreme Court provides two pathways for satisfying the significantly different standard, the Chakrabarty pathway and the Mayo pathway. The Patent Office asserted that the Chakrabarty pathway requires a showing that the claimed subject matter is markedly different from what exists in nature. The Patent Office noted that Myriad changed their understanding of the law, meaning that isolating a gene, even though it creates a non-naturally occurring molecule, is not enough for eligibility. Instead, eligibility requires the creation of something not naturally occurring, which is markedly different from what exists in nature. The Patent Office also noted that the Supreme Court has never held a claim reciting a natural product eligible unless it was structurally different than what exists in nature. And even then, the structural difference had to be marked. Thus, based on their interpretation of Myriad, the Patent Office concluded that a functional difference on its own cannot amount to a marked difference. Regarding Mayo, They asserted that the Mayo pathway required a showing that there is an addition of significantly more to the judicial exception. The Patent Office stated that factors B through F and H through L, which Bill presented on previously, of the guidance relate to the Mayo pathway. The Patent Office cited the much maligned gunpowder example as demonstrating that there are no magic words that automatically confer eligibility on a claim. Rather, examiners must give the claim the broadest reasonable interpretation and then examine the claim for eligibility. The Patent Office emphasized throughout the form that they are bound by Supreme Court precedent, indicating that the guidelines will only significantly change with a change in the law regarding the subject matter eligibility. In response to the guidance, many different organizations provided their comments as well, many of which noting the breadth of the guidance to reach subject matter not addressed by the cases the Patent Office based the guidance upon. In particular, the general themes of the comments were as follows: that it was inappropriate to issue the guidance without first providing the public with an opportunity to comment, that the guidance unjustifiably extends beyond the holdings in Mayo and Myriad, that DNA is a unique situation. Myriad's claims are concerned primarily with the information contained in the genetic sequence and not with the specific chemical composition. Also, that it was inappropriate to require markedly different structure while ignoring the function. It was also noted that applying a Wands factor-based type analysis when determining patent eligibility under Section 101 was an inappropriate standard. And lastly, additional guidance examples were required in the guidance. Many commenters have noted that these concerns were not just theoretical. Rather, rejections have already been received based on these guidelines in technologies that were not specifically addressed during Myriad or Mayo. On the question of whether or not the guidance will be suspended by the Patent Office, it appears to be unlikely. As I mentioned previously, the Patent Office emphasized throughout the forum that they are bound by Supreme Court precedent with regard to these guidelines. The Patent Office has also noted the importance of equipping the examiners with tools to apply the rulings of the Supreme Court regarding subject matter eligibility to cases currently pending. However, the Patent Office has continued to keep the lines of communication open regarding the guidelines. The Patent Office has invited the public to provide written comments that present their interpretation of the comments and to propose additional examples by July 31st of 2014. We also note that should comments be provided to the Patent Office, they will be posted for public viewing. Now I want to switch gears a bit and focus on a couple of recent cases that might provide the opportunity for some additional direction on subject matter eligibility under Section 101. In particular, two cases of note are In re Roslin Institute, which centered on product claims reciting cloned mammals, and Ariosa Diagnostics versus Sequinum, which centered on methods of detecting DNA in a sample. Starting with In re Roslin, this case was decided on May 8, 2014 by the Federal Circuit. A representative claim is shown here. As you can see, the claim is a product claim directed to a live-born clone of a pre-existing non-embryonic donor mammal. The claims have been rejected by the examiner as not being patent eligible under Section 101, as well as not being patentable under Sections 102 and 103. The case was appealed to the Patent Trial and Appeals Board, which affirmed the examiner's rejections, finding that the claimed clone was not a natural phenomenon that did not possess markedly different characteristics than any found in nature. The researchers appealed this decision to the Federal Circuit. The Federal Circuit affirmed the decision, holding that the researchers did not create or alter any genetic information. The Federal Circuit begins by noting that before the decision in Myriad, the Supreme Court opinions in Chakrabarty and Funk Brothers made clear that naturally occurring organisms are not patentable. The Federal Circuit held that because the cloned animal was an exact copy of the animal found in nature, the cloned animal was not eligible for patent protection. Rosalind argued that the clones are patent eligible because they are the product of human ingenuity and not nature's handiwork, but their own. However, the court found that Dolly herself is an exact genetic replica of another sheep and does not possess markedly different characteristics from any farm animals found in nature. The court explained that Rosalind's chief innovation was the preservation of the donor DNA, such that the clone is an exact copy of the donor. Therefore, Dolly's genetic identity to her donor parent is what renders her unpatentable. The court left open the possibility that having the same nuclear DNA as the donor mammal may not necessarily result in patent ineligibility in every case. But the court emphasized that the claims at issue do not describe clones that have markedly different characteristics from the donor animals of which they are copies. I want to note that the Patent Office, during the public forum, briefly discussed the holding in Rosalind and gave their interpretation. They stated that Rosalind added a new data point in support of the position that Chakrabarty's market difference test is the eligibility test for all natural products. They also noted that the holding in In re Rosalind affirmed the subject matter eligibility analysis is a case-by-case inquiry that focuses on what is claimed. Accordingly, the Patent Office finds support for their application of the Supreme Court precedent in this decision by the Federal Circuit. The next case I want to discuss is Ariosa Diagnostics versus Sequinum. In Ariosa, the District Court for the Northern District of California granted summary judgment, holding that the claims were not patent eligible because the diagnostic process utilized an abstract idea or a natural phenomenon. The case was appealed to the Federal Circuit on December 18th of last year. Amicus briefs were filed by interested organizations, including BIO and the San Diego Intellectual Property Law Association. Two representative claims are shown here. The first claim is directed to a method for detecting a paternally inherited nucleic acid of fetal origin performed on a maternal serum or plasma sample from a pregnant female. The method comprises amplifying a paternally inherited nucleic acid from the serum or plasma sample and detecting the presence of a paternally inherited nucleic acid of fetal origin in the sample. Similarly, the second claim is directed to a method for detecting a paternally inherited nucleic acid on a maternal blood sample. The method comprises removing all or substantially all nucleate and anucleate cell populations from the blood sample, amplifying a paternally inherited nucleic acid from the remaining fluid, and subjecting the amplified nucleic acid to a test for the paternally inherited fetal nucleic acid. In support of their position, Ariosa argued paternally inherited nucleic acid, or CFF DNA, is a natural phenomenon, and the claims merely added well-understood routine, conventional activity to that phenomenon. In other words, Ariosa argued that Sequinum did not add enough to the claimed natural phenomenon for the claims to be patent eligible. Sequinum countered these arguments, arguing that the claimed methods were novel uses of a natural phenomenon and not a patent on the phenomenon itself. Sequinum also argued that the claims are patentable because they do not preempt all uses of CFF DNA. We'll note that both parties agreed that neither CFF DNA nor the discovery of CFF DNA in a maternal plasma or serum is patentable because the presence of CFF DNA in maternal plasma or serum is a natural phenomenon. In granting the motion for summary judgment, the district court conceded that because the patent claims are drawn to a method for detecting the CFF DNA, the issue before the court was whether the steps of the claimed methods applied to that natural phenomenon are sufficient to render the claims patentable. The court determined that they were not. After setting forth its interpretation of the relevant Supreme Court precedent, the district court held that the natural phenomenon of CFF DNA is the only inventive feature of the claims, as the additional limitations in the claims either apply well-understood, routine, and conventional activity to the natural phenomenon, or limit the natural phenomenon to specific types of natural phenomenon which are also unpatentable. The court held that their conclusion conformed with the relevant Supreme Court case law, in particular, the decisions in Fluke and Myriad. The court rejected Sequinum's argument that alternative methods of detecting CFF DNA exist. Even though there were alternative methods, the court found that they were not commercially viable. It is interesting to note that the court applied the reasoning of Fluke, addressing an abstract idea, to the facts of this case instead of Mayo, which addresses the addition of something significantly more than the natural phenomenon in the context of this case. It is also interesting to note that the court relied on Myriad, which specifically states that the holding does not address method claims. The case illustrates the difficulty of applying the established Supreme Court precedent without proper guidance and appreciation of the issues. This case, along with other pending cases, provide the Federal Circuit and possibly the Supreme Court with the opportunity to further clarify an applicable standard in addressing issues relating to the patentability of method of use claims under Section 101. Some final thoughts. While it is unlikely that the Patent Office will suspend the guidance, it is worthwhile for the public to provide comments, which may help provide further clarification. In addition, it is worthwhile to monitor how the courts are applying and interpreting the precedent of the Supreme Court. These decisions may impact application of these rules and clarify the proper standards. Lastly, it is important to understand that the guidance is not binding law. As such, it is advisable to file claims that fulfill the tests provided by the Patent Office, but also are supported by the case law. Now to provide some strategies for prosecuting patents in view of the guidance is Jennifer Fox.
Thank you, Rashad, and thank you both for that excellent introduction and summary of not just the case law that underlies the guidance, but sort of what's happening now in the courts. And I'm going to try to give you a little bit about what's happening sort of in the PTO since the issuance of the guidance. I understand now, though, that significant difference means it's markedly different and that clones are natural products, so this should be easy. So I thought we'd start with looking at, since the guidance, what sort of claims are being allowed at the USPTO. Now, considering that the guidance was only issued in March of this year, things that are issuing now or this week, which would be on Tuesday, mostly were allowed prior to the official guidance being released. However, the interim guidance that we received from the office after the Mayo decision and after the Myriad decision were fairly well incorporated into the official guidance along with additional information. So even though these cases were granted based on allowances prior to the guidance, I think it gives us a good idea of perhaps what the PTO is comfortable with. So we are seeing diagnostic methods with particular active steps being granted, isolated sequences, provided that they're cDNA or provided that they are genomic altered in some other way, are being allowed. Primer sequences, whether they include artificial labels or whether they're incorporated into amplification method claims as opposed to specifically the sequences themselves, as well as we're seeing isolated polypeptides or at least some isolated polypeptide claims being allowed. And I thought it'd be useful to go through some specific examples of these. And we'll start out with the diagnostics. So in our first example, this is a case that we issued late last year. And it is a method of detecting the presence of or an increased risk of a particular type of cancer. This particular method involves obtaining a sample, testing the genomic DNA sample, determining a particular methylation status, comparing that status to some sort of reference, and then determining based on that comparison whether there's presence and increase or decrease in risk in a patient. You'll note in red the obtaining, the testing, determining, and comparison steps. But you'll also note that the detecting or measuring of the methylation status is in particular of at least 3 genes selected from a group of genes. And this is important, or at least it was important to the examiner when you look at the comments in the notice of allowance. In the comments, the examiner states the additional step of using a novel product that is not known in the art in a test to design and measure a law of nature in a specific setting transforms the claim to a patent-eligible practical application. So testing a correlation of methylated DNA in a limited scope of disease, which of course DNA methylation is a law of nature, but if you include a novel and unobvious product in the test in this correlation, meaning the selection of at least 3 of those genes from a group of genes, you are now into patent-eligible subject matter. So in this particular case, it looked like the examiner focused on the fact that even though you're in a law of nature realm, the fact that you have some sort of novel and unobvious piece to that particular method brings you into the field of patent-eligible subject matter. So let's look at another example. Again, this case was issued late last year. It's also a method of, or a diagnostic method. The method is for prognosing the patient with a particular type of sarcoma. In this case, this claim started as determining a patient was going to have a relatively worse or a relatively better prognosis. And it evolved into adding a step A, which is determining the level of expression of a gene, and one particular gene, in the sample of sarcoma cells acquired from the patient, and then comparing that level of expression to a reference and determining that if it's greater than or equal to, it is a relatively worse prognosis, versus then if it's less than the reference level, it's a better prognosis. And in the examiner's comments, we learned that it was in fact adding the additional active step to detecting the gene expression level of one particular gene that seemed to make the difference. This somehow transformed this method into patent-eligible subject matter. So looking at another diagnostic example. This is a diagnostic method where you're selecting an individual with a particular disorder. A particular disorder is related to a decrease in one or more digestive enzymes. The method involves measuring a level of a particular enzyme, here chymotrypsin, identifying the patient to be treated, having that subnormal level of chymotrypsin, and selecting the individual to be administered the pharmaceutical composition, which happens to be the digestive enzyme itself. The claim actually started with just measuring the level of chymotrypsin and selecting the individual to be treated. Somehow adding this step of identifying a patient to be treated as to having that subnormal level of chymotrypsin, again, transformed the claim into patent-eligible subject matter. And that's reflected in the examiner's comments in the notice of allowance, that the amended step set forth as a method for identifying the individual amenable to be treated with digestive enzymes. The claim scope is sufficiently narrow. We find this interesting that now it sounds almost like a policy decision that if in fact your claim is narrow enough and you are not precluding the entire world from applying the natural principle, in fact you may have been transformed, your subject matter may have been transformed to patent eligible subject matter. So looking at a few more recent cases that have come out since the guidance was issued, we'll look at a polypeptide case, and this one was actually issued this past week. Very short prosecution history, but the claim reads an isolated polypeptide having acetylbiohydrolase activity, and it's selected from a group consisting of, and the first being a polypeptide having at least 90% sequence identity to the sequence of amino acids 26 to 532 of seq ID number 4. And B and C are similar claims that you see in cases like this where you're now identified to a stringent hybridization probe, etc. But what's interesting here is the 90% identity and the fact that the identity is to a partial sequence. So if you note, seq ID number 4 in its entirety is in fact a naturally occurring protein. Now the prosecution history of this case did not involve a rejection or a written response. It did involve an examiner interview. And that's what you see on the slide is the substance of the interview is summarized. The examiner indicates that seq ID number 3 and number 4 are free from the prior art. However, he suggests limiting the claim to the polypeptide to 90% sequence identity to avoid other art and a possible rejection under 112 for lack of enablement. However, even though the claims here are not directed to DNA, those claims were in fact canceled at this point in prosecution. But the examiner did comment that seq ID number 3 is genomic DNA, quote, a product of nature. So the examiner suggested that the nucleic acid claims be amended to be directed to a vector or a plasmid comprising a heterologous control sequence to obviate a possible rejection under 35 USC 101. So in essence, the examiner is suggesting if you take your piece of genomic DNA and you put it into a vector, you may now be patent eligible subject matter. In another area that has to do with nucleic acid sequences, primer sequences. And we've seen rejections of primer pairs that have been claimed just as the sequence themselves. And here's a case where they were issued just a few weeks ago, and in fact the claims were originally directed to the primers themselves, but the allowed claims are directed to a method. The original claim that was a method is a method for identifying a particular plant by isolating genomic DNA, screening the DNA for a particular marker, and then identifying that that in fact is the plant that you were looking for. The allowed claim has transformed into something interesting. The method claim is, of course, again still identifying a particular plant. It was narrowed a little bit to a particular type of plant. But what I found interesting was in the part in red is the marker is now a particular marker comprising a polynucleotide that is amplified by PCR by a particular primer pair, which results in a particular nucleotide of 300 base pairs. So in this case, instead of claiming the composition of the primer themselves, you now have a method that incorporates the two specific primers to be used in a PCR reaction, which of course is what these primers are designed for. So what does that mean? Well, possibly in looking forward, we can look at how do we address covering these unique and valuable primer pairs, but avoiding the 101 rejection for claiming just the sequences as being a product of nature. Well, perhaps we can add a label. The label, of course, is the artificial piece, getting us outside of the 101 rejection. Or instead of claiming the primers themselves, a method of using the primers, so a method of amplifying a particular sequence comprising employing the primer pair. Or lastly, perhaps kit claims, kits that involve the primer pairs and any particular enzymes or any other reagents that are required for performing PCR. Genomic DNA. Again, I have not personally seen any cases where isolated genomic DNA is actually pending or has been recently allowed. However, in the case, the example that we showed earlier, it appears that examiners are suggesting that if you actually modify that genomic DNA by perhaps placing it in a vector, perhaps even additional enzyme digestions or something, may actually transform you into patent-eligible subject matter. So what about cDNA? These are example claims, again, from a case that was just issued in the last few weeks. And cDNA appears to be fine, which we all understand from the Myriad case, I guess. But the isolated cDNA, in this case, is isolated cDNA comprising a nucleotide sequence that encodes a particular cytochrome P450, wherein the nucleotide sequences encodes for an 85% amino acid identity. The amino acid identity is that set forth in seq ID number 4. And it also incorporates a particular function. But what seems to be key here is the examiner was satisfied with the isolated cDNA. Again, another claim in the same case was to a recombinant vector. Interestingly enough, the recombinant vector comprised the polynucleotide sequence, and it again encodes for the cytochrome P450. The P450 has to have a particular identity, again to seq ID number 4, and a particular function. So what about polypeptides? Well, this is an interesting one. Although the case that we saw that was allowed this week was to a particular polypeptide having 90% identity to a partial amino acid sequence, if we look at the guidance, it appears that the isolated polypeptide with the amino acid sequences of 1 to 523 of that same sequence would not be eligible since it's the naturally occurring polypeptide. Yet what is eligible is something with less than 100% identity and only to a part of the polypeptide sequence. Now, whether or not that trend will continue in the office or is this just one particular case remains to be seen. On another note, we need to keep in mind that the U.S., although we're still evolving the law around 101, the rest of the world seems to remain relatively constant, and actually in countries like in Europe, Japan, Canada, and Australia, genomic DNA and isolated proteins are still patent-eligible subject matter. For example, in the European countries, an element isolated from the human body or otherwise produced by means of a technical process, including a sequence or even partial sequence of a gene, may constitute patent-eligible subject matter. In Japan, Canada, and Australia seem to agree. In fact, Myriad's case with very similar claims was in front of a federal court in Australia, and that court upheld the validity of those claims. Now, that case is on appeal, but my understanding is that there isn't any indication that the outcome will be different on appeal. So what does this mean in practice? Well, again, these are suggestions as to what we might possibly do under the guidance that we have from the PTO as the law evolves. So first, remember that the guidance is not law. However, be prepared and try to prepare your clients for appeal. Really, the appeal process is the only way in which we can force this law to be evolved. Provide support for claims of isolated polynucleotides and polypeptides, especially if you're prosecuting internationally. Maintain pending applications, especially on commercially relevant subject matter. As this law evolves, if you have that specification with the support for isolated nucleotides or isolated polypeptides, and as the law evolves, you have the opportunity to go back and get those claims. Keep your international laws in mind, again, providing support for subject matter that's patent eligible in all countries, not just in the US. And lastly, stay involved. As a practitioner, the USPTO looks to us to provide comments. And in this particular case, we have, I believe, till the end of July to provide those comments. And we've seen in the past that these comments are actually incorporated into revisions of prior guidance, and perhaps we'll find the same result here. And so lastly, I just wanted to touch on some possible commercial implications. So if we were prosecuting in a box, this may be a little bit easier, but think about it more broadly. So for those in the large molecule therapeutic area, isolated natural proteins themselves may not be patent eligible, but slight modifications can create patent eligible subject matter. Pros and cons to that. Perhaps the design around of your competitor may be to use the natural product if it's not patent eligible. Consider your regulatory exclusivity, especially for large molecule therapeutics. Your regulatory exclusivity may provide the best or the most protection for your particular product. And the other thing to consider is the claims that are to polypeptides, whether they're 90% or 99% identical to all of the sequence or part of the sequence, appears to read on the natural product itself. So the question is whether or not the office and perhaps the courts will look for a proviso of the natural product. And in the diagnostics arena, it appears that if the claims have the active steps and not mere, quote, mere mental processes or just correlations to natural phenomena, those claims are allowable. Consider your kit claims, and consider perhaps incorporating your primer sequences into methods of amplification as opposed to just claiming the primer sequences themselves. And with that, we have a couple of minutes for questions. And it looks like we have a couple coming in here.
All right, so it looks like the first question is from Lee. Will preparing claims that comply with the guidelines produce patents that are so narrow that they are no longer worthwhile? I think we have to remember, as Jennifer just stated, that the guidance are not binding law. While it's advisable to prepare claims that are in view of the guidance, it is also important to remember that these claim drafting strategies, it's important to develop claim drafting strategies, I should say, that focus on areas that allow for broader coverage. Some of these areas were discussed today by Jennifer. Focusing on drafting these claims to recite additional elements or additional steps would be helpful. The guidelines, as currently drafted, do pose a challenge, but I should say the guidance. The guidance are not a complete barrier to getting adequate patent protection for claims that are directed to natural phenomena. In addition, it may be a worthwhile strategy to prepare narrower claims that meet the requirements of the guidance, but also prosecute broader claims that may ultimately be considered patentable as the law regarding 101 patent eligibility is being sorted out by the courts. So even though it presents a hurdle, I don't think that it's a complete barrier to getting meaningful and worthwhile patents. All right, looks like the next question we have is from Greg. How did the claims get around introducing new matter? Many seemed as if they added new matter. Many of the last claims covered.
So obviously with cases that were filed early on prior to the guidance, you will run into an issue of trying to meet the hurdle of written description and enablement. I think in these particular cases, a lot of the amendments were made really focusing on the method that was already described, but perhaps just not specifically claimed. Especially if you look at like the case where you added identifying a patient, the original final step sort of involved identifying that patient already, but it was really selecting the patient to be treated instead of identifying the patient to have the low level of expression of the gene. And the examiner seemed to really focus on, it was that low level expression of a particular gene that made it patent eligible subject matter rather than simply just the identifying step. Of course, as we go forward, we hope that it's a little bit easier to avoid these new matter issues. But again, you are limited, of course, to what's in your specification. But for example, things like primers. Primer sequences have a particular use. And I think that even though if you have a primary sequence and you haven't expressly said that that primer sequence is going to be used in a PCR method, I think that the average knowledge of the skilled artisan is likely enough to be relied upon in something like that.
Looks like we have another question from Greg here. How do these apply? I'm guessing he means the guidance. How do these apply to, say, a micro packaging with new materials?
I don't know his answer. So it looks like I'll try to take a stab at this. I apologize to Greg in advance if I don't answer his question completely. But my guess is in micropackaging new material or with new materials, I assume perhaps that's packaging known materials in like in a nanoparticle. Would that in fact overcome? I'm seeing we have an update here. Microchip packaging. I'm going to have to defer on that.
I'll take a stab at it. I think what would be important is something that we've been emphasizing throughout this presentation is that there has to be some type of focus on providing an additional step or an additional element in addition to something that would be considered either a naturally occurring phenomenon or a law of nature. Just reviewing some of the patent claims that the Patent Office has recently issued, it appears that preparing your claims such that that they're narrowly focused in a specific area is a way to avoid the hurdles of 101. So going forward, I think if you're prosecuting claims related to microchip packaging, I think the focus is not just on the microchip itself or the packaging itself, especially if it's old components, but adding some additional element that would differentiate or would add to what you're initially claiming here with the older technology.
It looks like we have one more question coming in. It has to do with the recent decision in Alice Corporation. While the claims at issue were directed to an abstract idea, it appears the court adopted the same approach used by the PTO with the guidance, citing Mayo as providing the proper framework. The question is, does the Alice decision validate the PTO's approach to preparing the guidance?
I'll take this one. As we know, Alice just was issued by the Supreme Court. The decision just came out last week. And Alice does mention that Mayo provides the proper framework for determining whether an abstract idea, law of nature, or natural phenomenon is considered patent eligible. But one thing that Alice does is that it indicates that the Patent Office provided the uses the correct precedent to prepare this guidance. But I don't think Alice validates the Patent Office's interpretation of this precedent. As we discussed throughout this presentation, the guidance goes well beyond the limited holdings of Mayo, Myriad, and other cases that are cited by the Patent Office. They developed a standard, the significantly different standard, which is not enumerated by these cases. In addition, the Patent Office developed a 10-factor test for determining whether the method claims are patent eligible, which also wasn't specifically cited or addressed in Mayo. So citing proper precedent when preparing these guidelines is essential, but it is also essential that the precedent is properly interpreted and applied. In this case, I don't think that the Patent Office applied that precedent properly. So even though Alice cites to Mayo, I don't think that it does lend support to how the Patent Office is actually applying this particular precedent. And we have one last question from Lee. The question is regard to stem cells. Under the guidance, would claims directed to isolated stem cells be considered patentable subject matter?
Well, I can take a shot at that one. So it looks like all things point to just simply isolating a stem cell. The result may come out very similar to the isolated genomic DNA result, which is the stem cell itself may not, in fact, be patentable just simply because it's isolated. It's likely that there will have to be some other modification. Keep in mind, though, if we look back to the Roslin case, the claim at issue is actually to the product itself. Now, we can debate all day long whether or not a cloned sheep is a natural product or not. But in fact, the claims that were not at issue, and they in fact were in a separate patent, had to do with the method. And the method was found as patent eligible subject matter. And I think in isolating stem cells and allowing those stem cells to provide certain characteristics or culture characteristics, it's still going to remain patent eligible subject matter. The exception may come in as it's statutorily or equivalent statutorily in Europe, that embryonic stem cells, in fact, are not patentable. However, other types of stem cells still are. And we may end up somehow in that same sort of scenario in the United States, maybe driven a little more by policy than by law, but using the legal framework to come to that outcome.
All right. Well, it looks like we're running short on time, so we'd like to thank everybody for joining us.
Thank you for watching Brinks, Gilson, and Leon's V-Panel, Patent Prosecution Strategies in the Wake of USPTO's Myriad-Mayo Guidance. If you are applying for CLE credit, confirmation will be sent to your email address with 4 to 6 weeks. Thank you again.